morality or results in outcomes that are repugnant to justice or morality or inconsistent with the Constitution or any written law. The effect is that the arbitration must be carried out in a way that is constitutional, and failure to which would be seen as invalid. Article 189 of the Constitution provides for cooperation between the national and county governments and provides that national legislation shall provide procedures for settling intergovernmental disputes by ADR, including negotiation, mediation, and arbitration. So the Arbitration Act generally provides for arbitration proceedings and the enforcement of the arbitral awards by national courts. The Act also applies to a wide range of arbitration matters, and however, the arbitration practice in Kenya has been said to have become a little bit cumbersome and more formal due to the involvement of lawyers into the practice of arbitration. So lawyers regard arbitration to be like litigation. They try to impose the same procedural rules which apply to courts in arbitration and which are not necessary in arbitration. And so they become more formal and more cumbersome, and it can also delay proceedings because of the involvement of lawyers and their practice of arbitration. And because of this, you see more matters going to court due to the dissatisfaction of the disputes. The referrals to court can be on matters touching on the substantive as well as the procedural of arbitration. There is also the Dispute Resolution Center, which is a non-profit organization founded in 1997, and these provide alternative dispute resolution services. There are also other acts which insist that disputes must go through alternative dispute resolutions. One of them is the Employment Act, which provides for disputes to be settled through ADR. And then there is the Kenya Ports Authority Act, the Kenya Railways Act, a lot of acts which provide that disputes cannot go straight to court until you have tried the ADR method first. Now, who is an arbitrator? According to Justice Raymond, who provided this definition 250 years ago, and which is still valid today, an arbitrator is a private, extraordinary judge between party and party, chosen by their mutual consent to determine controversies between them, and arbitrators called because they have arbitrary power For if they observe the submission and keep within their due bonds, their sentences are definite, from which there lies no appeal. Now, Kenya also has a lot of foreign direct investments. So, because of a lot of international companies situated in Kenya, we also get international arbitrations. Now, as a signatory to the New York Convention, the enforcement of international arbitral awards commences on the date the respondent receives a request for the dispute to be referred to arbitration unless the parties agree otherwise, as stated in Section 22 of the Act. So the arbitration proceedings commence by sending a notice in writing to the other side that they want to go to arbitration. Generally, the arbitration proceedings and the admissibility of evidence are agreed by the parties. But where the parties fail to decide on the procedure, then the arbitrator can determine the procedure. In compliance with the spirit of Article 5 of the New York Convention, court interference is largely limited to matters that are not arbitrable and to instances, among others, where interim measures may be required by the parties before the arbitral tribunal is set up. So under Section 7 of the Arbitration Act, the court interference is very minimal unless there is an interim measure which a party requires before the commencement or the setting up of the arbitration tribunal, and they have to go to the court to get an order before the arbitration proceedings have started. Kenya is a signatory to the ICSID Convention and is reportedly a party to more than 19 bilateral investment treaties. And therefore, under these bilateral treaties, the rules are normally applied for a party which is an international party, and for parties which are local. So one party can be international, one party can be local in a bilateral trade treaty. ICSID stands for International Center and Settlement for Investment Dispute. It is actually a branch of the World Bank, and most of the agreements entered into with the World Bank always have an arbitration clause where the dispute will be settled under the rules of ICSID. Also, many international companies doing business in Kenya tend to favor the well-established international dispute resolution centers and the ICSID seems to be the preferred institution for international investors. There is also the Nairobi Center for International Arbitration and the Strathmore Dispute Resolution Center, which are also popular for resolution of investment disputes in the region. The pro-arbitration regime in Kenya has had a positive effect on investor confidence in the country, especially since 2019. Kenya's economic growth has averaged at 5%, placing Kenya as one of the fastest growing economies in the sub-Saharan Africa. There is also a large portfolio finance corporation, and is the fourth largest country with the largest investment portfolio in sub-Saharan Africa in June 2020, and also ranks quite high in relation to Intelligence and Greenfield Performance Index. The World Bank projects positive growth in real GDP in Kenya. So it is favored because of the arbitration disputes and the enforcement of awards regarding arbitration. Now, arbitration cannot proceed unless there is a arbitration agreement. Not everyone can proceed to arbitration unless there is a valid arbitration agreement. So what are the requirements for an arbitration agreement to be enforceable? The key formal requirements for an arbitration agreement are set out in Section 4 of the Arbitration Act. These are the substantive formal requirements. So the Arbitration Act Section 4 states that the arbitration agreement must be in writing. It can be contained in a clause within a contract or in a separate agreement. It is considered to be in writing if it is a document signed by the parties, or there is an exchange of letters, telex, telegrams, facsimiles, emails, or not denied by the other party. Is also said that there is an arbitration agreement in existence. So if it is alleged by one party and not denied by the other party, then there is an arbitration agreement if in the exchange of statement and of claim and defense it is stated that. Requirements I have stated. For a separate document to be viewed as an arbitration clause to the contract in dispute, parties must expressly reference the separate arbitration agreement as part of the contract. So you can agree to arbitration even if there is no arbitration agreement to have the dispute go to arbitration. So what happens to unilateral clauses or optional clauses, where one party has a right to choose arbitration. The use of unilateral or optional clauses is yet to be seen in Kenya. However, given the legislative similarities in common law countries, it is reasonable to assume that where an optional clause is used, the Kenyan approach will be similar to that of the English courts. English courts have upheld unilateral optional clauses, giving one party the choice to take the case to arbitration. And in what circumstances can a party that is not a party to an arbitration, and therefore cannot be joined to arbitration proceedings? There are exceptions to this rule. On the death of a party, the agreement is enforceable against or by the deceased's personal representatives. In the event of bankruptcy, the trustee in bankruptcy adopts the contract and the terms are enforceable by or against the trustee. The Arbitration Act is silent on the position of individuals such as agents and heirs in relation to the arbitration. The court in one case, KNHA versus Masot, could lead the court to conclude that the third party had either authorized the parties to the contract to join it to their contract or chosen to accept the terms of the agreement. The court will give precedence to the rules, if any, agreed by the parties. In what circumstances can a party that is not a party to an arbitration agreement compel a party to the arbitration agreement to arbitrate disputes under the arbitration agreement? There must not be compulsion in any part of the arbitration process, and there are no known instances of this. The law recognizes the doctrine of separability. Arbitration agreements are treated as separate from the underlying contract. Kenya Anti-Corruption Bureau. Where the court stated that an arbitration agreement survives the contract's termination. So, to be unenforceable, the arbitration clause itself must be challenged for lack of intention to create a legally binding agreement. legal incapacity, lack of consensus, and termination of the agreement. Where death and insolvency occur, the agreement is not terminated. The obligations or rights under the agreement fall to the executors, administrators, or personal representatives of the individuals, respectively. What remedies are available where a party starts court proceedings in breach of an arbitration agreement or initiates arbitration in breach of a valid jurisdiction clause? The defendant must apply under Section 6 for the proceedings to be stayed. The application must be made no later than sought. The court will refer the parties to arbitration unless it finds that the arbitration agreement is null and void or the dispute is not covered by the agreement. Where there is arbitration in breach of a valid jurisdiction clause is yet to occur in Kenya. However, it is reasonable to assume that the arbitrator appointed under these circumstances will either reject the appointment or seek the parties' direction on how they wish to proceed. The local courts have no jurisdiction to grant an injunction for a stay of proceedings. For proceedings which have started, there have been no claims like this brought in any Kenyan court. Now, how do arbitrations begin? One cannot just start an arbitration unless an arbitrator is appointed. So, an arbitrator is normally appointed to start arbitration proceedings. Now, appointment of arbitrators is very important. Again, an appointment of an arbitrator cannot be there unless there is an arbitration. So, how is an arbitrator appointed? Are there any legal requirements to the number, characteristics, agreement say? Sometimes the arbitration agreement also has a name of the arbitrator who will arbitrate the dispute should there be a dispute. Now, where the arbitrator is named or designated in the arbitration agreement, arbitral proceedings are commenced in respect of the matter when one party serves on the other party a notice in writing requiring him or them to submit their matter to the person named or designated. Where the arbitrators are to be appointed by the parties, arbitration proceedings are normally commenced when one party serves the other party notice in writing, requiring them to appoint an arbitrator or to agree to an appointment of an arbitrator in respect of the matter. Where the arbitrator is to be appointed by a party other than by a person other than the party to the proceedings, then arbitral proceedings are commenced when one party gives notice in writing to that person, requesting him to make the appointment in respect of that matter. It is universally acknowledged that the quality of arbitration proceedings depend to a large extent on the quality and skill of the arbitrators chosen. The parties have chosen to opt out of litigation where a judge is appointed for them. Into arbitration, they choose their own judge. They are the constructors of their dispute resolution mechanism and are therefore presumed to know what best. There are several recognized ways by which the parties can agree to such a composition. They can exercise this right by expressly agreeing to the procedural appointment, which is in the arbitration agreement, or they can agree on the number and how they would be appointed. All arbitration law recognizes the rights of the parties. The parties can nominate a third party to make an appointment on their behalf. Once the parties have appointed the arbitrators, then their appointments be held, because they can either directly go to the arbitrator to act as the arbitrator, or they can adopt an institution without making other selection, and they choose the selection and appointment procedure from the institution. And this is also because the arbitration rules from certain institutions make life easier for the parties to have an arbitrator. And the parties then do not have to unilaterally or mutually decide. So by choosing the relevant rules in their arbitration agreement, the parties can incorporate such rules that they wish for the procedures to go through. Now, another fact is that the arbitration institution does not come into existence until the dispute has arisen. And that is when the institution is recognized and is appointed, and they have been asked to appoint an arbitrator. So it is at this point where the offer by the parties to the arbitration institution is made, and they can become effective and part of the arbitration agreement. So the arbitration rules generally become relevant only after the institution has come into the picture. Now, normally I've stated that the parties can agree on the number of arbitrators. If there is a failure to determine, then there will be only one arbitrator according to the Act. This is section 11. where an arbitrator provides that there will be two arbitrators, unless a contrary intention is expressed in the agreement, the two arbitrators will appoint a third arbitrator after their appointment. So each party can appoint one, and then the two arbitrators will appoint the third arbitrator. The necessary qualifications will also be determined by the parties and set out within the agreement. The courts only grant an application to set aside an appointment where it is satisfied that there was a good cause for failure or refusal by a party in default to appoint his or her arbitrator in good time. Only on granting such an application and with the consent of the parties can the High Court appoint a sole arbitrator. So you can see the powers of the courts are very, very limited. It is only on the application of the parties that the courts can intervene. Now, the arbitrator does not have to be a Kenyan national or to even have a practicing license to serve as an arbitrator. An arbitrator can be anyone. Normally, it is always wise to choose an arbitrator who is knowledgeable to your particular dispute. So, for example, in a construction